I think we're probably ready to get started. Hi, everyone. I'm Elizabeth Parker. I'm the senior civil appellate attorney at the Speaker Law Firm. Our firm is a boutique appellate firm. We have people who handle family law, and I'm on the other side of that doing civil and probate. Probably the only thing we don't really get involved in would be bankruptcy appeals and criminal stuff, although I do have a couple criminal, so that's, always an exception to the rule. Um, with me is Nicole Shannon. And Nicole, I will let you introduce yourself.
Sure. Thanks so much for having me, Elizabeth. So my name is Nicole Shannon. I am a lawyer with a private nonprofit called the Michigan Elder Justice Initiative. We started as a program within Legal Services of South Central Michigan, which is one of Michigan's regional legal aid programs. Eventually, we spun off, and while we still work very, very closely with our legal aid friends, both at Legal Services of South Central Michigan and elsewhere, we are now part of our own organization. And so we provide free civil legal representation to older adults and adults with disabilities who are dealing with abuse, neglect, and exploitation. Our program also houses the State Long-Term Care Ombudsman Program, which provides free advocacy to residents of licensed long-term care settings like nursing homes and licensed adult foster care homes and homes for the aged. And we do a lot of policy work. We've got some additional programs that we're working on, but our mission is driven by serving adults with disabilities and older adults. And so I do a lot of work related to long-term care, as well as guardianship and conservatorship. And I also work with a team of legal aid lawyers who handle those types of cases all across the state. So I'm really excited to be here today.
Well, thank you so much. Um, I'm glad you're able to sort of talk about what Michigan Elder Justice Initiative does. It was interesting to me that when you and I connected, which we'll talk about later, how we ended up connecting, um, to find out. I didn't know that it existed. And so sometimes we get those calls where it's just not someone who can retain us. And I'm glad to know there's a resource available to send them over.
Yes, people do love the free part, the free
Yeah.
legal services.
Well, and often in that community, that's, yeah, it's necessary too.
Yeah.
Um, well, let's kind of get just some basics out of the way. What, and a little bit of this, I'll do a little bit of a question answer with you, Nicole, because I know you live and breathe this stuff every day. What are guardianship and conservatorship, and how are they the same, and how are they different?
Sure. So folks will often encounter guardianship and conservatorship with the same client or kind of two sides of the same coin. They are different files. They've got different case numbers, but they're often heard together, and you might have essentially like the same trial or hearing for both a guardianship and conservatorship almost happening kind of simultaneously. The main difference between guardianship and conservatorship is only dealing with property, and that can be real property. That could be personal property like finances. And so that's conservatorship tends to be more restrictive in that way. Guardianship is dealing with kind of all of the rest of somebody's life. That could be medical decisions. It could be legal decisions. It could be where somebody is living. Guardians also do handle personal property. They can't really do much with real property. They can't sell it. Though they may have to maintain it. If somebody is owning a house, the guardian may need to ensure that there's not waste happening. But we could probably have a whole presentation just on the contours of guardianship versus conservatorship, but I tend to think of conservatorship as dealing primarily with finances and real property, and guardianship dealing with kind of all those ins and outs of everyday life for a person.
But do you find in your practice that those people are generally the same person in a particular case?
Not always. I mean, a guardian and conservator can definitely be different people. In some cases, you may have, say, a family member who is serving as the guardian, somebody who's really familiar with the wants and needs of values of their loved one. But for whatever reason, it might make more sense for a professional to be handling the financial side of things as a conservator, particularly when we're dealing with larger estates. And so I'll preface all of this with my little disclaimer, which is, like I said, I come from legal services world, so most of my clients generally don't have that much money. They tend to be indigent. But there are certainly situations where a conservator might need to be appointed, for example, if you're dealing with selling a house or something like that. So it certainly doesn't need to be the same person. It often is, though not always. And you might just find that people have different skill sets, different needs. And sometimes, frankly, it's just the easiest way for folks to reach a resolution by kind of dividing and conquering, especially when you've got kind of a family feud going, to be able to say, person A is going to handle the guardianship, person B is going to handle the conservatorship, to kind of keep the peace.
Yeah, that does make sense. How do we get to the point of appointment of a guardian, for example? I mean, I know we can get there through the mental health code, we can get there through Epic. What's the difference?
Yeah, so we can get there both ways. And essentially, the standard for guardianship is, um, it's not, the black letter law is not identical. You really do need to look at the two different statutes depending on where you are. The standard for appointment of a guardian is kind of the same concept under both, which is essentially you need to prove that somebody lacks capacity to make at least some decisions, and also that guardianship is necessary. So there really are kind of those two prongs. And so, like you said, we've got two different statutes that we're dealing with here. I think the one that often comes to mind is Epic. And so that is dealing with all conservatorships, minor conservatorships, all adult conservatorships, that will fall under Epic. But guardianship has two different codes that kind of govern the way those work. The mental health code governs guardianship for adults with developmental disabilities. And so just to kind of clarify, you can take a look at the statute for yourselves if you really want to go to sleep and are fighting insomnia. You can read through it yourself. But a developmental disability, it is defined as a severe chronic condition that is either attributable to some kind of impairment, physical or mental, or combination of the two. It has to be manifested before the person turns 22, and it's also likely to continue indefinitely. And then it has to result in some functional limitations in at least 3 areas of life. So that would be things like self-care, receptive and expressive language, learning, mobility, self-direction, and capacity for independent living. I want to point out that I think just kind of when folks commonly think of developmental disabilities, they think of some type of disability that's present from birth. And when it comes to the mental health code definition, that's not always the case. So you really want to look closely at the facts of your case. If you've got somebody who was maybe injured in an auto accident at age 19, and as a result, they are limited, they've got those substantial functional limitations in 3 or more of those areas, you are likely going to find yourself under the DD, the mental health code side of things for a guardianship. The EPIC guardianship is essentially for everybody else who doesn't have a developmental disability. That could be an older adult who's living with dementia. That could be somebody who is living with a mental illness, some other issue that is not a developmental disability, but has still impaired their capacity to make and communicate informed decisions. So you're going to want to look closely at the facts of your case. But the bottom line is conservatorship, that's all under EPIC. Guardianship, mental health code for folks with developmental disability is an EPIC for essentially everybody else.
Okay. And then if you're looking at the appointment of a conservator, are those same standards applicable?
Yeah, and so so the same standards. I mean, like I said, a conservatorship is really, since we're looking at EPIC there for everybody, you're going to be looking at, does the person, have some kind of an impairment that makes it so that they cannot manage their property, and that it's going to be that it will be subject to waste unless a conservator is appointed. There's also something else called a protective order that you can do. It's kind of like a conservatorship for a one-off situation. It might mean that you need to establish a trust. It might mean that you need to sign some kind of a care contract. If you have a need for somebody to handle financial affairs just in kind of like a one-off situation, then you'd be looking at a protective order as well. And you might not need that kind of ongoing conservatorship.
Okay, right. So I think we maybe at this point we can kind of move into some of the issues that brought you and I together, actually. So something you and I have discussed is the fact that not all developmental limitations or aging issues require the appointment of a guardian or conservator. Um, what's your experience in terms of some alternatives to full guardianship and conservatorship that maybe petitioners or family members or attorneys facing these types of cases might want to think through?
Sure. I think it's so hard in these cases because when folks are considering guardianship or conservatorship, they're very often coming to the court in a place of crisis where, um, you know, when we think about doing, sitting down in estate planning, you're giving yourself some time. You're sitting down with an attorney. You're kind of going back and forth on your wants and needs for long-term planning. You've probably given it some thought in terms of what you want to do. When it comes to guardianship and conservatorship, it's often because there's some type of precipitating emergency. Somebody was seriously injured, or perhaps you've got somebody with dementia and things have progressed to a point where they're really not able to handle things on their own. There's some type of emergency or urgent issue, mostly on the epic side. With adults with developmental disabilities, um, sometimes, unfortunately, guardianships are kind of given as an 18th birthday present, because you've got somebody who is turning 18. The folks around them feel like they're not able to make or communicate informed decisions in at least some areas of their life. And so a guardian is appointed at that point. And so we really do want to look at, because guardianship is such a restriction on somebody's personal liberties, we're talking about being able to marry or divorce, where do you live, what do you do with your things, medical decisions, often, travel, personal interactions, really all of these things that make us adults and the decisions that we get to make as adults are really kind of like on the chopping block when you're petitioning for guardianship. And so you really want to be thinking through potential alternatives to guardianship. And I'll say that one of the programs that the Michigan Elder Justice Initiative is doing right now, we've got a pilot project in 4 different counties, the Guardianship Diversion Program. And in Bay County, guardianship petitions being granted, it's actually down about 50% as a result of this really intensive work toward looking at alternatives. So, I mean, there are as many alternatives as there are people in the universe. You can really kind of design it to fit the needs of the individual. And I'll say there are going to be some cases where there simply isn't an alternative. You've got somebody who can't make or communicate informed decisions, and guardianship is truly necessary. But before you get to that point, you really want to be thinking about, what options might there be. And the statute does require that the petitioner and the court have to look at less restrictive alternatives. So one that is it's kind of sweeping the nation is supported decision making. Michigan has some statutes that are pending some bills that are pending right now, but really in the last like 5-6 years, I think it started in Texas and California, so hard to think of 2 more different states. They have implemented statutes that recognize supported decision making as an alternative to guardianship, and it's really just an approach. It started with the developmental disability community, and it encourages folks to kind of like formalize the way they make decisions. You kind of look to your council of family, friends, and sometimes professionals before you're making a decision on your own. And like I said, it's primarily used by folks with developmental disabilities, but it is used with increasing frequency for older adults and adults with other disabilities. It's really just formalizing the things that you and I do every day. If I'm in over my head with a car repair, I'm going to ask my father-in-law, who worked on the line at GM for 30 years, on what I should do. If I'm trying to figure out my tax issues, I'm talking to my dad, who's a CPA. If I'm trying to figure out some other thing, I'm trying to find people in my life who I trust to help me sort it out. And it's really just a matter of formalizing that a little bit more. Some states require actually written documents. Michigan does not recognize it in statute, but actually there was a recent decision out of the Wayne County Probate Court by Judge Freddie Burton, who determined that although the individual subject to the petition, the respondent was incapacitated under EPIC, guardianship was not necessary because because supported decision-making was an alternative to guardianship that was working for her in her life. And so even though it's not recognized in statute, there's nothing keeping the courts from, at this point, kind of considering that. The bills that are pending in the legislature right now would require that courts consider supported decision-making. Home and community-based services are often kind of overlooked, because so often when guardianship petitions hit, it's because you're trying to solve a problem. It's, this person's living in a dangerous situation. They're not getting the care that they need. There's hoarding, there's mental health issues, there's You've got somebody maybe with a physical disability who can't get up and down the stairs, or they can't navigate their home safely. Home and community-based services can often, if not completely solve those issues, certainly address them. And it's also a matter of, getting those services in place, because maybe it's not a capacity issue. Maybe it's, this person's in danger, but it's because they aren't aware of the resources that are available to them. But really, whenever we talk about alternatives to guardianship, I'm sure I'm, preaching to the choir here with this group, but I think we know that the gold standard are really those powers of attorney for finances, and the patient advocate designation. And so if you've got those in place, it's going to be a very rare situation where guardianship is going to meet that necessary prong, because even if you're completely incapacitated, you're in a coma, you're in a persistent vegetative state, if you've got those documents completed, it's difficult to think of a power that a guardian would need that wouldn't already be addressed through those documents if they're done in a really comprehensive fashion. The challenge is you do have to have legal capacity to be able to sign those documents. The bar is pretty low to sign. Just because you lack capacity in some areas doesn't mean that you lack capacity across the board. And I was recently talking with a couple of physicians with the University of Michigan Health System. And something they kept on reiterating is that just because somebody lacks capacity maybe to consent to complex cancer treatment, or an amputation in response to complications from diabetes, doesn't mean that they are unable to complete a patient advocate designation. They may be in way over their head when it comes to understanding the ins and outs of the medical issues, but they may be more than capable of saying, I don't really know what you're talking about, doc, or it's clear to the doc that they don't know what they're talking about. Can you talk to my son about this? I trust him. If somebody has to decide for me, my son can do it. The bar, it does exist, but it's very, very low. Obviously, if you've got somebody who doesn't recognize their family members, doesn't understand who's in their life, isn't able to communicate that, it's probably past the point of being able to execute one of those. But just because somebody lacks capacity in one area of their life doesn't mean they're not able to execute those powers of attorney. And then finally, limited guardianship. If you're filing for guardianship, there are probably going to be some areas that the person can handle. Can they handle having $60 a month, their personal needs allowance? Can they handle spending that at the nursing home, barber shop or beauty salon? Are they able to make some simple, straightforward decisions? Consider, what is the problem that you're really trying to solve here with guardianship, and what are those rights that you can still preserve for the individual?
Right. Just so in your experience, are courts aware, or I don't know, aware, but it's not the right word, but I mean, in your experience, are courts receptive to these sort of less than full guardianship if they're raised to them? Or are they kind of just like, look, I can either grant this or deny it, and that's that?
So I think that, so in my opinion, one woman's opinion, I think that courts are predisposed to being more restrictive just because the incentives are there. You want to protect this person, you're nervous if something happens that's bad, then it's going to come back on you. You don't want to be in the headlines because something bad happened. I don't think that it's because the courts aren't looking at it, but it comes down to you. So this is me talking to you all, who are attending this. You have to present this information. I think you've got to be really explicit when you're talking to the courts. If you are perhaps representing a respondent on this, or if you're representing an interested person who is not wild about the relief that the petitioner is seeking, if you want something other than what the petitioner is seeking, you've really got to be explicit about it, because the court is not going to do some independent analysis for the most part. You might have some judges that kind of have their own personal checklist of the things that they'll look at. And the petition does require to take a look, hey, do you have a power of attorney? Do you have a patient advocate designation? But it's pretty limited. If you want to get into the nitty gritty of somebody's life, to talk about why a guardianship might not be necessary, or why the relief that's requested isn't appropriate, or why it should be limited, the burden is really on you to spell that out. And so something that Elizabeth and I were talking about earlier is these hearings are kind of slapdash a lot of times. And I work in this world a lot. And so it was kind of a relief and a reality check to hear from Elizabeth that as a commercial litigator, she was kind of baffled by the lack of formality
Yeah.
and procedure in these cases. And I've said, I was a legal aid lawyer. I tried like four-figure debt collection cases that had full-on discovery orders and motions for summary and all of these type of, due process procedures in place that so often are just kind of blown right by in probate court. So it's really up to you. You've got to kind of push it and make it happen. So I encourage folks, submit a trial brief to spell out exactly what you want, because again, these hearings are often pretty brief. I was reading a transcript not too long ago for it was a husband and wife who were both having their guardianship and conservatorship hearings done at the same time, and the whole thing took less than 30 minutes. And it was contested. This was a full-on contested hearing that took less than 30 minutes to decide four petitions. So if you're going to represent, I think you really have to dig in your heels and be a zealous advocate, write a trial brief, put in your evidence, because you may not have the opportunities that you're used to in other types of hearings to make sure that you can, make your record. So I strongly encourage folks to do that. And if there's some type of relief that's available, something that you want the judge to do in crafting this order, you've got to be really explicit and kind of like lay it out for them on a silver platter, because they're not going to necessarily make that. They're not going to make that inquiry sua sponte. You've got to deliver that for them. And also, if you're on this call, these cases are often really challenging because it's a lot of pro se litigants. And so you can't even rely on your other parties, even if they're in agreement with you, to be able to support the position. It really is kind of, when you're the lawyer in these cases, you end up having to really carry the burden for not just your client, but procedurally to kind of keep things on track, knowing that you've got a lot of pro se folks who are also part of this, who may be aligned with you, maybe not, but they're not going to kind of keep the guardrails in place. That's really going to be up to you.
Yeah, no, I mean, yeah, like talking about our conversation earlier that, when we sort of connected, I was amazed. I mean, I've been handling, probate appeals now for a while. And every time I get into one of those files, um, and I find out there's one transcript and it was 30 pages long. And I'm like, wait a minute, we just deprived someone of their, right decision-making rights. And we did it in a motion hearing equivalent. Like I've argued about discovery longer than that. So it is surprising to me to see how quickly, and I do understand that, so an aspect of that is probably the court's own volume, and it needs to kind of get things through, and it wants to have a level of protection. And like you said, nobody wants to get on the news because they're the judge who didn't grant a conservatorship or a guardianship and then something terrible happened. But I think it ultimately, it seems to me like, from what I'm seeing, that there is a lot of overreach to avoid that. Um,
Yeah.
and to try to like protect someone who doesn't necessarily need protection.
Yeah. And so I think that, especially this, this is an appellate conversation. You've got to really work to preserve your record, because if you're, a typical civil litigator, I think you're going to be given so many opportunities to kind of build that record. Whereas this is kind of like, you're just off from the get-go, and that first hearing might be the hearing, depending on the way your court operates. And of course, there are, we're 83 counties, 79 different probate courts. Every judge is going to handle things differently, but you've really got to be ready to go from the first word to preserve your record. And so that's why I'm such a strong advocate of filing a trial brief, or filing some, put it in writing, preserve your issues, because you might not have the opportunity at the hearing to get that. You might not have the opportunity to get it through motion practice or through discovery. You've really got to preserve those issues at the outset, because there might not be a second chance to do it.
What are the rights that the respondent has in that setting?
Sure. So, I mean, you've got a right to appointed counsel. And I give, my heart goes out to appointed counsel who are taking on these cases, because often they are very poorly compensated. And they're being asked to do essentially a full-blown trial for maybe, what amounts to an hour of their hourly rate. And so it is really, really challenging to do this job with the very limited resources that you've been given. You've got a right to you've got a right to an independent medical evaluation. You've got a right to call your witnesses. You do have a right to appeal, but you don't have a right to appellate counsel. And so when we think about the rights that are at stake here, The fact that we don't have a right to appellate counsel is something I could go on about
Mhm.
for days. But I mean, we do have rights to appellate counsel in other civil cases that implicate, serious due process rights. We've got them in termination of parental rights cases, where you've got the right to appointed counsel on a, in those types of civil appeals. We don't have them here. Um, you've got a right to cross-examine. You've got a right to be present. You've got a right to, if for whatever reason your disability makes it not practical or not possible for you to appear in court, you've got a right to have the hearing come to you. I think with
Didn't know
Zoom,
that.
that is,
That's interesting.
yeah. And I know some judges have done that. They'll have the hearing right there in the nursing home, or they'll have it right there in the hospital. With Zoom, that's changed a lot. And so
Yeah.
I'll just caution attorneys who are representing really anybody in these cases. Zoom has its pluses. I think, as we've all seen, Zoom has its pluses and minuses. I mean, it really is great. You really have to know your client. I think for some of my clients, Zoom is wonderful, especially if I can be in the room with them when it's happening, so that, we can confer and things like that, when we've got moments off the record. Um, but also, and sometimes it makes them more comfortable. They are doing the hearing right there in their living space, and so it makes it easier. But particularly with clients with, visual and hearing impairments, for me, it makes me really nervous because Zoom can make your client seem far more incapacitated than they really are. I mean, I don't know how many of us have felt kind of silly. I think everybody, many, many times. Um, I can't hear you. Can you hear me? What did you say? I've got and so if I've got a client whose capacity is being questioned, the last thing I want is for them to look confused, or like they're unaware of what's going on over Zoom. And so you really have to
Yeah.
consider what makes sense for your client. And you might have to push too to get that in-person hearing, because not every court does that at this point as a matter of form. Some do require it. Some say you must be on Zoom. Some are kind of a mix. You've got to know your court, but also know your client. What is going to put your client in the best light and allow them to participate in the best way? Because maybe it's going to be sitting comfortably at home, feeling in a comfortable place, knowing that they can participate. Maybe it's going to be going into court and being able to see everything in person and not going, what did you say, over Zoom? So there are a lot of rights. I'd love to hear from Elizabeth to talk a little bit about the recent In Re GM case about capacity findings, which is really kind of what brought us together when I saw that this case had been decided by the Michigan Court of Appeals, because I thought it was some really interesting facts and some really tremendous advocacy, because these cases are challenging. They're very rarely appealed. They're challenging to win. And this was definitely not a slam dunk. So I was hoping Elizabeth might be able to talk to us a little bit about it.
Yeah, for sure. And thank you for the compliment. So when the case came in the door, my initial thought was, oh, this is not gonna get any traction. Just initially reading through things. And then the more I dug into it, and particularly looking at the court's reasoning, it really, I don't know, it felt not it felt a little icky. I don't know how else to say it. Um, the protected person is an older lady. She lives by herself, but she's kind of a hoarder. Um, she had a lot of dogs. She at some point was looking to breed dogs, and then the dogs got a virus, and so they were sick, and there was that whole little situation brewing in the house. Um, she'd also had some financial issues. She had a tendency to like to let bills accumulate and then pay them at the end. So she, wouldn't pay her electric bill for months and months and months, and then would make a big payment, just before it's about to be shut off. Um, and so what happened was there was actually a report made by her son, who is not in the country, to APS, and they came out, did an investigation, saw the situation with the dogs, didn't like that, got the police involved in terms of getting the dogs removed from the home. And then a petition was filed. And what was interesting is in this case is that, and I think you see this probably a lot, is, there are two children. There's also a daughter who lives locally, and they were not aligned at all. The son was, very much of the position that his mother lacked capacity and needed, care, and quite frankly, didn't feel that his sister, the daughter, was the appropriate person for that. Felt that she actually also lacked capacity. And so, he was not in favor of her becoming the guardian or the conservator for their mother either. The daughter actually agreed that she should not be the conservator or the guardian. Then she felt her mother did not need one. The testimony that came out at trial was that her mother had basically always been like this. She'd always been a hoarder. She'd always done things that, the rest of us in the room might consider not wise. She had a habit of renting out extra rooms in her home in order to gain some extra income, and she rented them to people who had some criminal backgrounds. She talked about this being something that she wanted to do as sort of a give back to a segment of the community that had a hard time finding housing, and she felt some degree of compassion in wanting to do that. Um, the the reviewing court, the probate court rather, took testimony from two different experts. She actually went out and hired her own expert to dispute the testimony that was coming in from the initial expert presented by the petitioner. But those experts didn't actually really disagree that much. Everybody seemed to agree that she was of average intelligence. The petitioner's expert said, well, I think she used to be a lot smarter. And I think what we're seeing here is some cognitive decline. But, right now at her ability, her capacity, she's at average level. And, really just commented on the fact that there was a hoarding situation. And so he thought that that was probably evidence of some mental illness. Um, the expert that she went to for her examination agreed, average intelligence, and said there may be some, degree of decline, but that isn't enough. She still has capacity. She still understands what she's doing. She understands the decisions that she's making. They might not be the decisions you and I would make, but they are her decisions to make. Well, the probate court rejected the analysis that came in from her doctor, saying, well, she'd already had the examination with the petitioner's expert, so she knew how to fool the test. And that just didn't make sense, since they really, to be honest, weren't that terribly opposed in their opinions, right? Um, so the court did, order a guardian, ordered a conservator, and ordered that it be the daughter who was willing to do it, but said, again, I don't think this is necessary. So on appeal, we argued a couple of points which the Court of Appeals agreed with. First, it was interesting that throughout the proceedings, the trial court kept saying, if you would just sign a durable power of attorney, we could resolve this. And they apparently at one point in the proceedings reflected on the record, there was a break in the proceedings where they were talking about, would she execute a durable power of attorney? And she wanted to know what that, encompassed. And then she came back and the decision was made through counsel that she did not want to do that. So then the probate court went on to order a guardian and a conservator. And my question on appeal was, if she has capacity to execute this durable power of attorney, how can she, therefore, if she has capacity to do it and also capacity to decline to do it, she cannot lack capacity sufficient for a guardian and a conservator to be imposed. And the Court of Appeals did agree with that. They actually just sort of discussed it in a footnote. But for me, I mean, I thought that was like outcome determinative. It's just, I mean, you can't be both ways. Um, the second thing that I think was significant about that ruling is they really talked about, someone of average intelligence may experience some cognitive decline. I mean, we will all experience that more likely than not as we get older. But that in and of itself doesn't establish incapacity. We may have people losing their some of their cognitive levels they experienced before, maybe some of their physical abilities, but that in and of itself doesn't demonstrate a lack of capacity. And so the Court of Appeals really, rejected the probate court's analysis on both fronts. Now, what they did do, and I thought the outcome of this was interesting too, they sent it back for additional findings. And ultimately, the petitioner, within about a week of that opinion being issued to us, just withdrew their petitions, and just said, okay, we're done. And so for something that they've, struggled so vigorously to get, they really weren't interested in supporting it on remand. Um, So I thought that was an interesting, outcome, not necessarily part of the opinion, but just an interesting post fact afterwards. But that's how you and I connected, was talking about those issues.
Yeah. I just want to add, so and something as we were talking about all of this, like I mentioned, it's interesting to get kind of a reality check for somebody who's a general civil and commercial litigation attorney, because so often when I'm in probate court, I'm like, "Ah, this can't be right. This feels so weird," and it's just the way that we operate in probate court. Um, can you tell me just kind of briefly about some of the things that surprised you going through this record as somebody who is like a general civil commercial litigation attorney, when it came
Yeah.
to the way that this really high stakes civil litigation was handled?
Well, so one thing in this case in particular, the hearings were stretched out over a couple of months. There was this initial hearing, and then it was adjourned a couple months, and then it was adjourned a couple more months. And each time there were like little issues that were talked about on the record, and then it would just be adjourned. And I kept thinking as I was reading this, if the need is so readily apparent, why are we okay with all these adjournments? Like, the obviously the respondent wanted the adjournments because she wanted the chance to gather some resources and to get her own examination done. And so that just for me, like, it sort of triggered not this idea of why isn't the court doing something quicker, but more along the lines of, I don't think this court really thinks she lacks capacity, because it feels like you would be doing something right away, right? um, the fact that the ultimate decision was made so quickly was definitely a surprise to me. Um, the idea that these reports come in and they're just full of hearsay and there's no real objection to anything, um, you know, that again was shocking to me. I don't know why someone should be able to, like for example, as a GAL, submit a report that's just replete with hearsay, and nobody even questions the GAL, let alone the subject or the person who purportedly made all these statements. So that was surprising to me too. Like, just the lack of formality and the lack of sort of evidentiary integrity. Um, Surrounding a proceeding that is so important for someone who is the subject of that proceeding. So those were things that really, for me, stuck out significantly.
I'm so glad that you talked about the GAL because I know that's something that we both wanted to talk about. Um, something that I've always found really unusual about these types of cases, and I understand why it is, but I still think it's strange, is, the courts use guardians ad litem to go out and serve as the quote unquote eyes and ears of the court, to advise the individual not only of their rights, and to kind of find out if they want to contest the petition, if they need counsel, but also to do this independent fact finding and report back to the court. Um, and to have this really high stakes civil litigation where you're supposed to be meeting a clear and convincing evidence standard, decided in large part based on kind of this hearsay within hearsay, sometimes this triple hearsay, reporting from the guardian ad litem, has just never really sat right with me from a due process perspective. And I think there's so many reasons for this because the guardian ad litem, they've got incentives to kind of keep things moving. They are reliant on the court for appointments. And I'm not trying to impugn anybody's integrity, but I do think that just kind of the system set up to kind of keep things moving. You know what judge wants, let's keep going. Um, so often they're not in a position to be able to really communicate the gravity of the situation. I've worked with a number of clients who simply did not really understand what was at stake when it came to a guardianship. Often, I think guardians ad litem will kind of soft battle things, say like, would you like some help maybe with what's going on? Would you like somebody to help you with these important things? And who doesn't want help? If you're really in a crisis situation, sure, I'll take some help, not really understanding what is at stake here. That help might mean you're not going to live in your home anymore. You're getting moved into a nursing home, and all your stuff's going to be thrown into a dumpster. Um,
Yeah.
that's not the help they were really envisioning. So often the guardian ad litem is really looking at what is best for the individual. And we do know that like often the guardian ad litem that is supposed to be your role is, looking at best interests. But I think so often that's kind of where this um, kind of smooshing happens because the ultimate decision is not based on best interest. It's based on clear and convincing evidence that somebody's incapacitated and that guardianship is necessary. It's not, would guardianship help this person or would it be, what's best for this person? I think that's kind of where things get a little off the rails. Um, and really, we should be having full hearings on these things. If the guardian ad litem is willing to issue this report, we've got a courtroom,
Yeah.
we've got a witness stand, we've got a probate register that will take pleadings and we can swear people in. Can we do some real fact finding? Can we do some real evidentiary hearings here as opposed to relying on the hearsay of one person who's really got this outsized kind of role in all of this? And courts are the statute does say that the guardian ad litem's role terminates once counsel is appointed if that person wants to contest it. I think often the court will keep that guardian ad litem on kind of as like a little bit of a backseat driver, which always makes me nervous
Hmm.
because I'd rather just make my client's case as opposed to worrying about having all of this hearsay within hearsay within hearsay. So
Right.
I guess if you've got a good guardian ad litem who's agreeing with your position, by all means, keep them on. But if you've got somebody who's kind of undermining your case, I try to get it out. I try to get them out as soon as I can because it's really difficult kind of having, like I said, that backseat driver with all of it. It's just a really strange way, I think, to make important decisions.
Yeah. Well, and I have a different case that I've worked on for a while, and the guardian ad litem actually did kind of like take on this whole new, persona as like almost like a second judge. Like anything the guardian ad litem said, the judge was just like, well, the GAL said it. She's impartial. And I was like, well, wait a minute. Like, I don't know that she's impartial, first off. And secondly, we are in that particular case, we were dealing with someone where a guardian and conservator had already been established, and then there was a trustee involved. And everyone was of full and complete agreement that the protected person lacked capacity at that point, and yet the GAL was getting involved when it came to some of the beneficiary issues and who should be beneficiary and saying things like, well, she doesn't want her money to go to this person, and it's like, well, wait a minute, haven't you weren't you just in this report telling us that she lacked capacity, and now you're presenting hearsay from her that we don't know the setting in which you asked this question. We don't know how you asked it. We don't know what you presented her with. Um, and the court was again just very willing to nod along and say, well, basically the GAL says it must be right. So we can just go with that.
Yeah, and it's a really uncomfortable place to be because I think when we're litigating cases against opposing counsel, we understand we are here because we disagree. We are here,
Mhm.
well, we are here because our clients disagree, and we're here to make those arguments on behalf of our clients. Um, but when it comes to kind of like bringing that same, putting the GAL under that same microscope that we would any opposing party, everybody's suddenly very offended by it.
Yeah.
And actually, the Wayne County Probate Court has in their training materials for appointed counsel something to the effect of like, don't be too mean to the guardians ad litem because the court appointed them and trust them for a reason. And I'm going like, oh my gosh, like I've got like
Yeah.
this super powered witness now that I'm not
Mhm.
allowed to like question. I mean, I'm not trying to question anybody's integrity. I just think that they don't have all the information, or perhaps they're not
Right.
perhaps it's not being accurately reflected to the court. Um, and so it's a really challenging spot to be in, I think, when you're litigating these cases. And so you've got to be mentally and I think strategically prepared because you're not cross-examining any other witness. It's the guardian ad litem that is held in esteem by the court. And try as we might, the court's going to have some opinions and feelings about that. So when you're going about this, I think you have to be kind of careful and really strategic and almost kind of surgical when you're getting into these issues. And I think, what I try to do is just present my evidence as best I can to demonstrate that maybe the guardian ad litem just didn't have all the information. It's a tough
Mhm.
job. They had limited time and resources to do this. Here's the full picture, court. And if only the guardian ad litem would have had the full picture, then we would have come to a different conclusion. But it does feel almost like there's a shadow judge sometimes, and
Mhm.
it's an uncomfortable place to be.
Yeah, yeah. I will tell you something else that actually it occurs to me that I was shocked by was the use of confidential reports that went to the judge, and none of the parties, well, at least not the defending party, saw them or could access them, but the judge referenced them in making the decision. Based on some information in this confidential report, I am deciding X, Y, and Z. And I'm thinking, how does that happen? Like I couldn't try a breach of contract case and just submit a confidential report from my damages expert to the judge and have the judge say, cool, like I'll just rely on this confidential report. So what are the parameters there? How does that happen? What do you do when that's happening?
So the
Is it common?
confidential, yeah, I mean, the confidential report is supposed to be available to the interested persons, the interested parties in the case. And so that should have been something that was available to you. Now, the court, when they keep like the physical file,
Mhm.
it is kept confidential from the public, kind of in the same way. If
Yeah,
anyone litigates personal protection orders, those are confidential from the public, but the parties, of course, it's part of due process. You need to be able to see what's going on to litigate the case, but we don't need to tell the whole universe about
right.
it. Obviously, there are plenty of reasons, and we're used to having like full and open records and hearings, but this is one thing where public policy, we've determined that that's not the case. We're going to keep these records in guardianship and conservatorship cases confidential. So those should have been provided to everybody. If they were going to admit it, those are things that are provided to anybody. It's challenging if I want to look at that if I've got a client who's maybe interested in modifying or terminating their guardianship and I want to see that file, I'm not able to just look at it. I would imagine that many of us, before we jump into a case that's already been going for a while, we want to look at the file before we get that retainer agreement signed or before we sign that, send that engagement letter or before we file that appearance. Um, you've got to work with your client to get it because they're the ones who can get it. You can't, because at that point you're just kind of a stranger. And then your only real option is to file an appearance to get it, which is not something I would recommend, because then you're in no matter what it says.
Yeah,
Um,
right.
and so,
Yeah,
yeah, that's something that should have been provided to everybody in that case. But these are really, I mean, I think I had a previous colleague described these cases as shockingly casual. And I
yeah.
think that's a really good way of thinking about the way this is handled. And it sounds like when it came to providing like this very, very important information to you, people just handled it in a really shockingly casual way.
Yeah, it was weird because there were emails going back and forth saying, "Can I have a copy of this report?" And it was a report from the GAL, and she said, "No, it's confidential to the judge only." And I'm like, "What? That does not make sense to me at all."
Nope,
Um,
that
so
sounds like an appealable issue to
yeah, oh
me.
well, yeah, it's definitely. But as I'm sitting here appealing it, wondering like, does this just happen? Like, and it's just accepted, and it's I'm the odd one out. Thinking that it's so outrageous, but. Um, Yeah, it's just it was again, like I said, one of those things that just when you come from a different background, that when you see it happening, it plays right into that shockingly casual analysis.
But
Um,
like I said, it makes me feel like I'm not just living in a different universe. I'm going like, yes, this is strange and shouldn't be happening. So to hear people from other practice areas kind of parachute in and go like, oh, what are you guys doing here? Makes me feel like so grounded
yeah,
because I
good.
agree. What are we doing here? What's
Right.
going on?
Well, we do have about 10 minutes left, so if anyone has any, questions that you'd like to drop into the Q&A or the chat, you know, we'd be happy to talk to, answer them to the um, best extent that we can. Um, did you have any, sort of final thoughts or anything, Nicole? And
No,
just,
I mean, I recognize so many names here, and so they probably could have given this presentation just as
Mhm.
easily as I could have. So if folks have other, if you want to say, actually, I don't think that's quite right, that's just fine. I guess, it really
Should have
is
said
up.
questions or
No,
criticism.
yeah,
Anything you
questions,
got to say,
criticism,
put
any
it
of the
in
above.
there.
No, I think it just really is up to us. Like, this is not, I would say this is not business as usual when it comes to civil litigation, where the discovery order and the scheduling order is going to take kind of like keep everybody on track. I
Mhm.
think these cases, more than any other cases in our court system, are so reliant on like individual attorneys to maintain due process because the guardrails are not going to be there unless you force the issue in so many cases. And so you've really got to force the issue for your clients. And you've got to, you've really got to craft that record too, so that you've got everything in there. Because again, like the casualness, it bleeds into the way that like the hearings are conducted. Especially because we don't have plaintiff defendant. You've got usually, kind of the assortment of family members standing there. And so when you've got, the court's just kind of generally taking Q&A as opposed to making sure everybody's got their, opportunity to speak, everybody's got the right to be cross-examined, everybody has the right to cross-examine. I mean, it gets complicated fast, and I can understand why, just in the interest of kind of moving things along, things tend toward the casual. But you've really got to force the issue and make it happen the way you need. I see we've got a question. Should we, when
Yeah.
serving as guardian, let them automatically send our report to counsel and unrepresented parties, or leave that to the court? I would expect, I've typically gotten them directly from the guardian ad litem, and I believe I'd have to look at the court rule and I'd have to look at the statute. I believe that it's supposed to be served by the guardian ad litem. I don't think that courts typically send them out as kind of like a courtesy, although probate courts are all fiefdoms unto themselves. So I can certainly see that being maybe like the practice in your court. And so long as that's the practice, then great. But typically when I've gotten my guardian ad litem reports, they've been served directly by the guardian ad litem to me. And typically they've sent them via email, which I always appreciate as a courtesy, because these cases can move really quickly. And so when things are stuck in the mail, it gets to be really challenging.
Yeah, and
So
I will
thanks for
say
the
from
question.
the appellate side, the review that I've done, I have never seen the court send them to somebody. I've only seen them shared and served by the GAL. And so I
Yeah,
think, um, I think that the presumption would be that they would come from the GAL to everyone
yeah,
involved.
I think so too.
I wonder, and this is a question I think I have for the people who are attending. I mean, those who serve as GALs, have you ever had issues with the court not wanting you to give a report out? I mean, and again, I don't know if anybody will answer or not, but I mean, to me, it sort of seems like um, there's a close relationship a lot of times between GALs and certain judges, and so I wonder how much that impacts upon the ability to, you know, do something that you think the judge might not like, you know.
Yeah.
But like I
I
said,
guess
that kind of goes back to that issue you're talking about is, are we are we using that, function correctly?
yeah.
Here's another one. Um, in a scenario where the parties generally agree that the ward does require a conservator, but the debate is whether the proposed ward has sufficient mental capacity to make an intelligent choice as to whom to serve, can the proposed ward be called to testify? Would that be suggested?
So I think so the question of, because in the statute, the person with the number, essentially with like the number one priority to serve, I think outside of whether there's a guardian, if there's a guardian or conservator appointed in another state, that person has priority. But that is a very, very rare situation. The much more common situation is where there isn't one. In that case, the person with number one priority is the choice of the individual. And so I would say a few things. One is, there is not a mental capacity requirement when it comes to the choice of the individual. And if you are having a guardian appointed, then you necessarily lack capacity in like at least some area of life. Otherwise, you wouldn't be able to appoint somebody. The Court of Appeals has only addressed this, I think, one time. And it's too bad, because I really wish they had gotten to it. The case got mooted out because the individual passed away while the case was, I think, as when the case was pending with the Court of Appeals. And in that case, the trial court, probate court judge said that the individual could not, essentially, they were not going to listen to the individual when it came to their choice of guardian, because they were incapacitated. And so why would they listen to them? And to that I say, the statute says you have to. I mean, how
Yeah.
could you, under what circumstances could the individual's choice of guardian ever be relevant? Because you only get a guardian if you're incapacitated in some way. So I think to answer the question, I would push back on, like, I don't think that there's like some mental capacity threshold for the individual to state their preference. I can certainly see a court wanting to find out more about, because really all you have to be is suitable and willing. You go through the analysis. Number one priority is the choice of the individual. Then you kind of go down through, like if you've got a power of attorney or things like that, close family members, and the very bottom is a corporate guardian. Um, but I would push back and say, there's not a mental capacity threshold. I think to be able to name the individual, I can certainly see a court wanting to do additional inquiry into why that person, like the suitability of the individual, and perhaps hearing from the what from the respondent would be helpful in that way. But I'm really curious about kind of like how this would have gone down. But I would push back and say, I don't think there is a mental capacity threshold in statute for it. I think that if you name the person, you name the person, and then it's up to the court to determine whether or not that person is suitable and willing.
Yeah, yeah. That's what I'm thinking. I mean, it's not like the choice is outcome determinative. It's still going to be subject to review and consideration by the court. But it would be interesting to, like you said, to see how that plays out. If they're, how can you say their choice matters if you're not actually allowing them to express that?
Yeah, it's like, well, you have to be incapacitated enough to get a guardian, but have enough capacity to be able to name somebody. And I don't think the statute splits
Mm-hmm.
hairs in that way. Um, but I
Mm-hmm.
can definitely see a court wanting to make that kind of inquiry about not so much, do you have capacity to make this decision, but more into, okay, let's find out if this person is really suitable, because those are the two
Right.
things, suitable and willing.
Yeah. Yeah, that seems to me like that would be the nature of the attack would be on the suitability then, as opposed to
Yeah.
on ability to just state a preference.
Yeah.
But-
Yeah.
Well, we are at got like 3 minutes left. We're scheduled to go for an hour. So if there are any other questions, obviously we'd be happy to do our best to answer them. And hearing and seeing none, I think we'll bring it to a close then. So thank you again, Nicole, for being here with me. I appreciate it very much. And thank you, attendees, for attending. Um,
And I want to thank you, Elizabeth and Speaker Law, for inviting me, because this really did just happen when I saw your really interesting appellate decision. I said, I want to talk to you about this. This is interesting, and
okay.
some, some really challenging facts that are, I think, good news for individuals subject to guardianship petitions.
Yeah, and we are trying to get it published. We haven't heard yet,
Yeah.
whether it will be, but it would be nice. I mean, because I know there's just not a lot of, um, there's just not a lot of published cases in the probate field, as a whole, and let alone on these particular issues. Um,
Yeah.
oh, the case is it's in Ray GM, and I can tell you the docket number if it's something you want to pull and take a look at. It's 373743. That's the guardianship file, and the conservatorship is 373744.
Yeah,
Yeah.
and I just saw in the chat the question about having to consult with the protected person for conservators. I know, it is different for conservators when it comes to appointing the person. I think that statute gets into the wishes of the individual about um kind of connection to the state. Um, but yeah, I do think that uh, like I said, I wouldn't be surprised. I think that like making that inquiry with the individual, I think you'd have to base it around like suitability and not the mental capacity though.
And we do send out to our registered attendees uh, post webinar takeaways and a link to the recording. So if there's anything we've talked about that you'd like to see again, or just some summary of the discussion, we'll get that out to everyone as well. All right.
Thanks. Thank you so
Well,
much again,
yep.
Elizabeth.
Thanks, everyone. Thanks, Nicole. Thanks for everyone attending.